Welcome to another edition of Question and Answer with a Criminal Defense Attorney. I am Mark Solomon, a defense attorney in Denver, Colorado, and today's question is about harassment. But before we get going, don't forget to click like on this video and subscribe with the little bell next to it to be notified of future videos. What is harassment? Now, harassment is not technically what's called a lesser included of assault. However, I'm going to put a card here for my past videos on assault so that you can look at them. Often when somebody's being investigated for assault and nobody was actually hurt, then they will charge somebody with harassment. So, what is harassment? The statute of harassment carries A through H as far as the things that can be done where you're charged with harassment. Now, very specifically in the front, you see here, a person commits harassment if, with the intent to harass, annoy, or alarm another person, he or she does any of those things. So this is what's called a specific intent statute, meaning they have to prove that you intended to harass or annoy or alarm another person in the course of any of these things. They don't, notice harassment is part of the definition. They don't define it. So that is up to a jury to define what would be harassment, the intent to harass. However, the most common variety of harassment that I see, especially in domestic violence cases, is the subsection A, which is the strike, shove, kick, or subjects the person to any physical contact. So you could literally just tap a person on the shoulder over and over and over and say, am I annoying you yet? Am I annoying you yet? Am I annoying you yet? And that contact combined with the intent to annoy, in that example, would be harassment. But it can be a number of other things. H is another very, very popular one that I've done a lot of cases on, the insults, taunts, and challenges. However, let's zoom in on E, because I think the phone harassment, this is E, which is phone harassment, and this is where somebody initiates some sort of communication or directs language to another person through any one of those lists of things, generally speaking over a phone or a computer, in a manner intended to harass or threaten bodily injury or property damage. Now, I get a lot of these too. People are big into texting or Facebook messaging or TikToking. It doesn't matter. Any sort of way you can communicate some sort of communication with the intent to harass or threaten injury or property damage. That would be this subsection E for phone harassment. And it also covers obscene languages, not just threats. Here's a slightly different part of the same statute, which is F, G, and H. And this is, again, prank calling, which is F. G, repeated communications late at night. I've done these cases too in trial where somebody was calling at 1, 2, and 3 in the morning. Our defense was that it was middle of the day for him because he worked night shift, but she worked day shift. So that would qualify under subsection G for inconvenient hours. So H is the insults, taunts, and challenges. And that's where if you make an insult, taunts, or challenge or communication in an offensively coarse language to another person to provoke a violent or disorderly response. If you've ever heard the term fighting words, that's what this subsection H covers. So H is fighting words, G is prank, F and G are prank calling. Going back to subsection E, that's phone harassment, and the greater statute as a whole covers all of these things. The next question you should be asking is, what's the penalty for this? It's a Class 3 misdemeanor, so it has a maximum penalty of up to 6 months in jail. So it is the lowest level misdemeanor, but it's still not a good thing to be charged with. So that is the question and answer for today. If you would like to submit your own question, you can always put it in the comments below, email me, or put it on Twitter. And as always, you have a right to remain silent. If a police officer is asking you questions about where you've been, what you have, what you know, anything, you have a right to say, I don't want to talk to you, or if they persist, I want a lawyer.